let's go ahead and get started. My name is Christian Dawson, and I'm Executive Director of the Internet Infrastructure Coalition, also known colloquially as the I2 Coalition. I'm going to tell you a little bit in a moment about who we are and what we do, but I'm going to start out first by giving you the subject matter for this morning's brief presentation and conversation. Our goal today is to teach you a little bit about the full scope of Section 230 in the internet ecosystem. We've got here today speakers from within our own organization, the people that build the infrastructure of the internet, but also colleagues in higher education and in public and research libraries. Our goal here is to explain to legislators and regulators and people who are working on Section 230 and the possibility of Section 230 reform. We want to make sure that they understand the scope of Section 230 and how it is leveraged, particularly how it is leveraged outside of the small group of companies that people are focusing a lot of the conversation around when it comes to social media. We want people to understand the breadth of Section 230 usage beyond how it is used specifically in social media. So that's going to be the subject for today. As we're going to walk you through how it's used throughout the rest of the digital ecosystem. But first, I'm going to take a moment to tell you a little bit about I2C, who we are, and who our members are. So, in short, the internet industry is comprised of three sectors, and we are the internet infrastructure sector. We sit between the transmission sector, which is the telecommunications pipeline that delivers content to end users, and the content sector, the people and companies that create content, which is social media companies and many companies that are producing the content that exists on the internet. We're the companies that rack and stack servers in data centers. We are the companies that build the infrastructure on which content is stored and then accessed. And the member companies of the I2 Coalition are the companies that build that vital infrastructure that makes the digital economy move forward. Those companies include VPNs, web hosting providers, cloud services, data centers, domain name providers, and the members of our organization are the companies that build this healthy and competitive ecosystem that allow the internet to continue to survive and thrive, and the companies that build the content, the businesses, the digital economy, which is really just the economy these days, to actualize on their dreams and ideas that move things forward because they have the infrastructure that we have developed accessible to them in order to accomplish those goals. And to a great extent, we are able to do that because lawmakers have allowed us to do that in a limited liability environment. So we're going to get more into what exactly we mean by that in just a moment. Intermediary liability protections are the core of what we mean when we talk about limited liability environment for the types of companies that build the infrastructure of the internet. We have created an environment where the barriers to entry for creating a cloud company, creating a digital infrastructure provider are low enough that we can create an innovative, flexible, and freedom-focused environment because of tools like Section 230 of the Communications Decency Act. Section 230 of the Communications Decency Act was enacted in 1996, and it's a federal law that gives internet companies protection from liability for user-generated content disseminated on their platforms. It's one of the foundational laws upon which the internet was built, and the scope and number of Section 230 reform proposals that we're talking about right now in general conversation throughout the legislative arenas. Many of them may propose significant liability risks for I2 Coalition members unintentionally because people don't understand the scope of how Section 230 is used in the internet's infrastructure. So I'm going to go ahead and I'm going to spend a moment trying to debunk three myths about Section 230. The first is that it was written for social media. Section 230, like I said, became law in 1996. Now let's just take a look at this brief timeline that I threw together. Friendster launched in 2002, MySpace in 2003, Facebook in 2004, YouTube in 2005. It's clear that Section 230 has been actively leveraged by internet infrastructure companies, libraries, and educational institutions long before social media was an active concern. So it clearly was not written for social media. Let's go ahead and take a look at the next myth that we're going to debunk this morning. It's special rules for internet companies. Actually, Section 230 protections extend to all online intermediaries. Those include not just our cloud-focused organizations, but libraries, archives and museums, educational institutions, clubs and civic associations, newspapers and magazines, and many, many more. So it's not just a small handful of social media companies that leverage the protections that Section 230 provide. It is the vast majority of the people that are providing digital services online. Let's go ahead and move on to the third and final myth that we're going to debunk this morning in my opening. It is blanket immunity for intermediaries. I can't stress this enough. It's not true. Section 230 does not provide blanket immunity. Illegal content, for instance, has no legal protection. Under 230, providers are still required to remove material that's illegal on federal level, such as copyright infringement. So it is not blanket immunity for intermediaries. So exactly what is Section 230 and how does it relate to the internet's infrastructure? So it's a protection for intermediaries to touch content without being considered the publisher of that content. And there are lots of reasons why it's important for an intermediary like a cloud provider, like our member companies, to be able to touch third-party content without being considered the publishers of that content. We're going to walk you through the language real briefly. 230C, protection for Good Samaritan blocking and screening of offensive material. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected, or any action taken to enable to make available to information content providers or others the technical means to restrict access to material described in paragraph 1. So really clearly, I just wanted to show you that what it is I was saying before is definitely in there. There's no mention of social media here. Let's go ahead and make sure that you understand the definitions that are put here. And I'm not going to go through all of this like I did before, but I wanted to highlight that when in the statute, they define interactive computer service, all these are clearly spelled out. When I highlighted this section in number 2, where it says, where it talks about interactive computer service, including specifically a service or system that provides access to the internet and such systems operated or services offered by libraries or educational institutions who we have invited to help us speak today. So, as I said before, these are not special rules for internet companies. They are rules that govern the internet's infrastructure, the internet ecosystem broadly, including the libraries and educational institutions that we have today, and that they are clearly foundational and fundamental elements of intermediary liability that are used by the cloud providers that we have here today. And I'm going to walk you through 6 of many that I could have chosen, examples from within the internet's infrastructure industry where Section 230 intermediary protections allow us to perform basic internet functions where we touch content and we don't want to be considered the publisher of that content. So let me walk you through these 6 examples. So let's go ahead and jump to the first one. The first one is filtering spam. When we implement spam filters, we're setting up systems that make judgments on what content is junk mail and what is legitimate mail. So we're touching the content. Section 230 protects us from being liable for those judgments. Let's go ahead and go to number 2. It's setting up keyword block lists. One way we ensure our networks stay clean and safe is through the use of blacklists, block lists, and deny lists, which require content level decisions that Section 230 empowers us to do. Next up, employing anti-malware software. Malware detection software makes content level system changes, and we can employ those tools that keep us safe because of 230 protections. Next up, this is one of the things that we wrote 230 to be able to do, setting up parental control filters. We touch content when we try to keep sensitive content out of the hands of minors in ways that Section 230 allows us to do. The 5th is reducing drive space, but more broadly, when we change the configuration of a user's account, we're leveraging the protections that Section 230 provides because we are directly touching their content. And then a little bit more broadly on the following, cloud providers couldn't take on the liability of allowing forums to exist on their networks without Section 230 protections. So here's 6 clear examples within our industry of how we leverage Section 230 to be able to provide services throughout the internet. I'm really excited to have a bunch of experts that are going to tell us a little bit more about how 230 is leveraged within their ecosystem. As I said before, we are very pleased to have people from the public research library communities and the higher education communities. What I'm going to do is I'm going to introduce each of our 4 panelists today, one by one, and I'm going to ask them to spend a few minutes talking about how Section 230 is leveraged within their own community. At which point, I'd like to ask that the attendees of our webinar today raise their hand or type questions into the chat if they would like to engage our members, and we can make this a collaborative panel where people on the call, people on the webinar, can ask us questions or clarifying comments that they'd like to make around what it is said today. But let's go ahead and start. We have 2 members of the IT Coalition here, James Bladel from GoDaddy and Sydney Schneider from Rackspace Technology. And they're going to start us out by giving a little bit broader perspective on 230 from the perspective of internet infrastructure companies before we jump to comments from public research libraries and higher education. So James, would you start us out by giving us GoDaddy's perspective on 230?
Sure. Good morning. Thank you, Christian, for the introduction, and thanks everyone for making the time to attend today. My name is James Bladel. I'm from GoDaddy, and if you know GoDaddy, you're familiar with us because we are the world's largest domain name registrar, but we also provide a number of other services for small businesses and our like web hosting, email management, and online payment systems. We like to think of ourselves as a toolkit, an online platform for small and micro businesses, well below the federal definition of a small business. Most of our 18 million customers are just getting started. Maybe they're still at the point where they're just transitioning from a full-time job or a part-time job and launching their venture online. So we provide a variety of services, all of which that are very critical under with the protections under Section 230. So I'll never miss an opportunity as a domain name registrar to point out that that domain names are not websites. They are independent of each other. A domain name registrar creates a domain name, but the web content itself lives with the web host, which could be at the registrar or could be on another network, which may or may not even be visible to the registrar. And so when GoDaddy moderates content, we moderate it mostly as a web host under our terms of service. And only in extreme cases would we ever take action against content as a domain name registrar. But I think it's important to understand this concept of proximity to content for all the different elements, both within GoDaddy and the industry more broadly. As Christian pointed out in his slides, it takes a lot of companies cooperating at a lot of different layers in order to deliver content to end users across the internet. And it's very important that we don't have dissimilar or contradictory moderation practices occurring at different levels of that stack. In our view, those entities that are closest to the content, for example, social media or companies like that, have more responsibility to moderate content on their platforms. And the further you are removed from that content, those companies should be afforded the greatest amount of protection from liability associated with moderating content. Otherwise, everyone would be at risk for content that came across their wires, and everyone would then feel compelled to both monitor and take action, and it would result in a very fragmented and dissimilar internet experience for folks around the world, and even within the same network here in the United States. Anyway, Section 230 is incredibly important to GoDaddy. Setting aside the current political environment, we rarely see Section 230 come up in the context of content moderation. I know that's what's grabbing all the headlines right now, but for us, Section 230 is critically important in getting ourselves removed from disputes that involve third parties. And usually that's a dispute, a commercial or legal dispute between two of our customers or between one of our customers and a third party. usually, in most cases, most commonly, those folks will try to include us into those disputes, or try to force us to adjudicate or resolve a dispute. And we don't believe that's our place as an infrastructure provider. We believe that's something for arbitration or for courts or for mediators, but that's not our role as a domain name registrar or web host. And Section 230 allows us to essentially remove those from those disputes. And that, I think that encompasses probably 80% of our involvement of the law. So, when we look at potential reforms, I think our ask would be that this concept, that was on Christian's slide and that I'm kind of outlining here, of proximity to content or a stack of different companies and providers, is recognized in potential reforms or potential legislation, and that those companies who are immediately responsible for content have the new obligations, any new obligations, and that the maximum protections are afforded as you go further down the infrastructure stack. We've also noted that, and I know this has come up previously, is that potential modifications to Section 230 right now, as the law stands, is everyone is afforded the same protections. But if that is complicated or amended, they could create an environment where only the largest and most equipped companies are able to comply with the law, and small and medium-sized companies, and GoDaddy definitely fits the category of a medium-sized company when compared to big tech, would struggle to comply with the law. And I think that's something that we would also ask policymakers to keep in mind as they look at potential amendments. So that's essentially what I wanted to convey as a domain name registrar and a web host, that we kind of have a split personality. We do more content moderation on the web host side, but most of our involvement with Section 230 happens on the domain name side, and it's usually to help us get out of disputes between our customers and third parties. And again, anyone who is in the business of publishing content, or especially monetizing and curating content, probably has a greater responsibility than anyone at the infrastructure layer who needs to retain maximum protections under Section 230. So I hope that's helpful. I look forward to your questions, and I'll turn it back over to Christian. Thank you.
Thank you, James, for getting us started. I appreciate it. We are now going to turn directly to Sydney Schneider with cloud provider Rackspace.
Thank you, Christian. So Rackspace is a multi-cloud solutions company. And what that means is we provide fanatical experience to customers who host their infrastructure in Rackspace data centers, as well as their multi-cloud environments. Our customer bases range from small to medium businesses to over half of the Fortune 500 companies. And along with our I2C brethren, we are the backbone that allows our modern internet economy to work, just as Christian explained earlier. So I've been at Rackspace for 20 years. And for most of that time, I've worked with the anti-abuse team. This team is responsible for enforcing the acceptable use policy for Rackspace customers. This team investigates complaints sent to abuse@rackspace.com. Those complaints can range anywhere from spam complaints, hacking complaints, to content complaints, copyright infringements under the DMCA. So at Rackspace, this team consists of 3 people globally. We've handled over 4 million complaints just last year alone. So between the systems and tools that we have in place to automate some aspects of the job and reviewing the content for legitimacy, they did this really by taking quick action to identify the source of AEP violations, working with our customers to remedy that violation. So just because a complaint came in doesn't mean we have a bad customer. A ticket from our team is really just the beginning of a conversation that we have to work with the customer to do better. Sometimes the customer resolves the violation on their own, and other times our customer success team is available to work with the customer to secure their environment and prevent future violations from occurring. So just like James said, we're the intermediary between the complainants and our customers. So Section 230 provides Rackspace protection to have knowledge of these complaints, work with our customers, resolve these expeditiously. And as a result, we maintain a very clean network. These complaints can come in from sources from all over the world, including law enforcement. Our team has maintained a great working relationship with our partners in law enforcement, also over at NECMEC. In fact, just recently, I joined the Texas Advisory Council for the National Center for Missing and Exploited Children because of that close-knit relationship. So just to give a non-technical analogy for those of us on the call that are not as technical, think of Rackspace as a city and my team, the anti-abuse team, as a police force. If there's something violating a law that's being stored inside of a file cabinet, inside of a closet, within a bedroom, that's being subleased by someone who is leasing that apartment from an apartment complex. As soon as the police are made aware of that violation, the investigation can begin as to whether or not that law was actually broken. So without that complaint, without knowledge of that matter, the city and the police would have no obligation to monitor what's inside of that filing cabinet or the room or the apartment or apartment complex within that city. So in this analogy, the elimination of Section 230 protections would now make the city responsible for monitoring on that minute level. So bringing it back to Rackspace, in this scenario, Rackspace would not only have to increase the number of employees that we would have to have in order to be responsible to begin proactive monitoring of the network, but also so would our customers. And the resources needed to achieve such extensive monitoring capabilities throughout the multi-cloud network would be significant, adding an overwhelming cost to doing business. And imagine the impact that it would have on small businesses that don't have the resources of Rackspace or GoDaddy or other I2C members. So that's what I've got. I'm going to turn it back over to you, Christian.
Thank you so much, Sydney. That was so clear and concise, and very appreciated. I hope that you also queued up some thinking. That I want people to start thinking about what questions they have, because we will be moving to questions after our next two speakers. I am so excited that we have guest speakers from the Public and Research Library community and the higher education community. You might wonder why we are pairing cloud infrastructure companies with libraries and higher education, but when we are trying to make the point that Section 230 is not simply a tool that is focused on the needs of social media, it really behooves us to make sure that those of us who rely so heavily on Section 230 who are not a part of that community have our voices heard. And so we have been banding together to try and make sure that we provide that education. And next up to give their perspective is Greg Cram, who is a member of the American Library Association and the Association of Research Libraries, also with the New York Public Library as the Director of Copyright, Permissions, and Information Policy. Greg, we would love to hear your perspective.
Yeah, thanks, Christian. Let me just tell you a little bit about the New York Public Library before we get too far down this. We are not a tech company, or at least not traditionally a tech company. We have 92 sites spread across 3 boroughs of New York City. We have 88 neighborhood lending libraries. They're your traditional lending libraries. They're the neighborhood libraries where you go to check out books. We also have 4 world-class research libraries where deep thought and deep consideration is made, where projects are written, where books are created, and where real research happens. Our collection contains more than 56 million items. And before our closure for COVID, we had more than 16 million visits. During our closure, however, our digital collections platform had more than 77 million page views. And that's a pretty big number for us. We're pretty happy about it. We are an important provider of internet services both before and during the pandemic. Although our physical locations were closed in 2020, we left the Wi-Fi networks up and running in our branches. And we found that although we were closed, there was still activity happening on these networks. When we investigated, we discovered that at a number of our locations, folks were actually using the Wi-Fi signal that had been leaking or bleeding out from our buildings. We found that students would sit outside the library so they could use our Wi-Fi to attend school that had moved to virtual environments. We saw job seekers that were laid off during the pandemic using our internet to find jobs, and others who just wanted to stay in touch with loved ones who were using our internet connections to be able to reach out to those folks. So why am I here? Well, I'm the Director of Copyright Permissions and Information Policy. My job is to expand access to collections as broadly as possible. And although most of my focus is on copyright issues, my title includes information policy. And 230 reform is squarely within that information policy because it implicates how we can advance the progress of knowledge by providing access to diverse viewpoints and information. So why is a library here? Well, not only do we rely on Section 230 for some of our activities, but 230 reform implicates a number of library values. As Christian mentioned, libraries are name checked in Section 230, and so we have a history of being involved with 230. I'm here today to talk about both and to encourage legislators to consider how changes might have unintended consequences on entities like us. So let's start with the importance of 230 to libraries. Although we aren't a social media tech giant, and you should know that because when I said 77 million hits and I was excited about it, that's like a couple of hours in social media land. Section 230 still impacts libraries like ours. We rely on 230 every day. During the pandemic, much of our community programming moved online. That means we were hosting classes, lectures, and events using online interactive computer services. Over 53,000 New Yorkers attended NYPL programming in the first 3 months of the pandemic alone. It shows that New Yorkers needed to make connections in a time when we were under lockdown. One service libraries provide is a promoter of public discourse. If we were forced to over-censor our programming, we might lose that public discourse service. And if someone violates our general policies and rules during one of these events, we need to be able to mute that person without incurring liability for the speech made during the event. I should note that we are a private not-for-profit company. We are not a government entity. So we want to avoid taking on liability if we mute someone who's violated our policies. We also, another way that we take advantage of Section 230 or leverage Section 230 is we encourage the public to help us learn more about our collections. And we do that in a few different ways, including asking the public to help transcribe and annotate our collections. For example, the Library of Congress's By the People project is a crowdsourcing platform that solicits transcription and annotation of collection items from the public and makes that transcription and annotation available back to the public. The National Archives Citizen Archivist Project invites users to contribute to the National Archives catalog by tagging, transcribing, and adding comments to records. And that means that we receive a lot of transcription and other information about our collections that we make available to the public. One project in New York Public Library that we're proud of is the Menus Project, where we encourage people to help us get data out of old menus so that we could start to understand how menus were put together, what kind of dishes were on those menus, and how the prices of those items have changed over time. Sometimes when we get comments back, or sometimes when we get this annotation, nefarious actors will post their own offensive content in these platforms. Section 230 means that we aren't the publisher of that content, and it means we can remove those spurious entries without then taking on the liability of a publisher for that content. These projects are innovative projects that help libraries organize and provide context to collections faster than simply relying on human catalogers. So without Section 230, or if 230 is reformed in a way that takes away these privileges, these activities might cease so that we just don't take on that additional liability. That means we might lose these rich conversations and educational opportunities where the public not only can help us understand our collections more, but they can interact with renowned authors, musicians, and thinkers. So as legislators think about 230 reform and addressing misinformation, libraries might be able to provide a helpful example. Libraries regularly encounter misinformation and disinformation in collection items, and we help patrons navigate these issues by providing context and expertise, and our work has had some impact with the public. In survey after survey, libraries are ranked as one of the public's most trusted sources of information. In 2016, a Pew Research survey found that 78% of adults say that libraries help them find the information that is trustworthy and reliable. 78%. That's a pretty remarkable number given the declining trust the public has had in institutions overall. And we believe that this trust is linked to libraries' adherence to a core set of values. So as we think about Section 230 reform, I want to bring these values to the forefront for your consideration. The first library value is around intellectual freedom, and that's the right for every individual to both seek and receive information from all points of view without restriction. Some of the reform proposals would impose requirements that would be significantly costly to implement and manage, and that would raise the bar for entry for new and innovative entities so high that no startup could ever meet that bar. That would lead to a marketplace of ideas that is dominated by a few players with no competition, harming intellectual freedom. The second value we should consider is the equitable access to information. Some 230 proposals target sites that rely on advertising revenue to provide free services to users. And our concern is that these sites will then have to transition if 230 reform, or if these proposals are advanced, these sites will have to transition to models that require paid subscriptions, limiting the access to information that's important to our patrons. And finally, privacy is a value that we should consider. Some proposals require the creation and adherence to a set of best practices, and although those best practices haven't been written yet or are not yet promulgated, these best practices should respect the privacy of users. We shouldn't be trying to expose every user every time someone posts something. So some final thoughts. As you work on Section 230 reform, keep in mind that libraries like mine rely on Section 230 every day to deliver needed services. We aren't one of those large tech companies, but we still rely on 230 all the time. 230 reform impacts not just large tech companies, but entities like libraries that are combating misinformation by collecting, organizing, and providing context to information. We want you to adopt library values, the library values of intellectual freedom, of free speech, equitable access to information, and privacy as you work on solutions to 230 or potential solutions to 230. These values have made libraries one of the most trusted institutions in the country and might be a way forward on this issue. So to learn more about research libraries in Section 230, check out the Association of Research Libraries' recent issue brief on this subject, and we'll post a link in just a second. It was created, this issue brief was created to help research libraries understand Section 230 and how reform efforts might impact our ability to deliver needed services to our patrons. I look forward to the rest of the conversation for today.
Thank you, Greg, so much. Greg, we look forward to hearing more from you in the question period, which is going to start right after our final speaker. So we'll have about 10 minutes of questions. So if you have one, time to get it in is now. Our final speaker for the day is from higher education, an EDUCAUSE member. We have Beth Cate from Indiana University, who is a clinical associate professor at the Paul H. O'Neill School of Public and Environmental Affairs. Beth, thank you so much for being with us today.
Thank you very much, Christian, and thank you all for taking the time to attend today. So let me just say, by way of brief background, as I offer some comments and some thoughts on this, I'm a faculty member, as Christian mentioned, in our public affairs school here at IU. Before that, I was actually counsel to IU for about 13 years. And so some of my thinking on this issue and thinking that I brought into some of my work as an academic now relates to what I have seen from the sort of operational side, if you will, of universities and how they deal with exposure to liability. So, and while I was in that role, information law issues and policy issues were a significant part of my brief. So with all that in mind, let me say, I think colleges and universities are certainly part of the broader ecosystem that Christian began this session by saying this is really what we want to expose you to, the broader ecosystem that would be affected by Section 230 reform. And to some extent, we partake, I think, of a little bit of both of the kind of networks and network managers and also the libraries, and share so many of the values and interests that Greg was just talking about. Colleges and universities provide network access to a vast array of students and personnel, including for their incidental personal use of the internet, to members of the public. We have libraries that themselves are open to the public, as well as our own faculty and staff and students. In the course of internal network management, I think colleges and universities, some of them anyway, engage in some of the same functions Christian was mentioning earlier, and Sydney and James were mentioning, and obviously for many other institutions, they are partnering with all of the backbone entities that prior speakers have been talking about. So colleges and universities look to 230 for protection, both with respect to some of those network management functions, but also as content hosts, to the extent that they have sites where they have third-party or user-generated content showing up. And there are many examples of those as well. You have colleges and universities who are hosting on their servers student newspapers, for example, that then may have comment sections, as many do, where anyone can jump on and talk and say things that might generate complaints. Campus community classified ad spaces. There are a number of those, auction sites, blogs, discussion boards that are hosted in connection with courses or other programs, community science projects, not dissimilar to what Greg was talking about before. So there are a lot of activities that colleges and universities engage in that are affected by the prospect of Section 230 reform, because Section 230 provides protection from litigation over these activities. And that's very important. And I'll say a little bit more about that in a second. But the core of Section 230, I think, in this higher education space is it lets colleges and universities offer these services to support teaching and learning, scholarly research, and public service. That is the mission of higher education. And if they were liable for user-generated content, for example, they'd likely shed the sites that host such content, and they'd likely curtail public access to their networks and facilities, because the risk and cost either of monitoring up front on the one end or facing litigation on the other would simply skew the balance and cause colleges and universities to contract their offerings to the detriment of the mission that I just outlined. If colleges and universities or their vendors, all of the partners in that backbone array that we've been talking about today, face liability for ordinary network management and maintenance activities, the cost of education, I think, would certainly increase. And that's another topic of great and necessary concern to Congress and to the society as a whole, the cost of education. Section 230 doesn't give colleges and universities a free pass to censor online speech. Christian mentioned before that there are existing exemptions in Section 230. But I'll also just mention, public colleges and universities remain subject to First Amendment constraints on what they do and how they react with respect to speech by stakeholders in their communities. And publics and privates alike hold strong academic freedom values that translate into broad protections for expression, including expression of unpopular and minority views. Even actually the Foundation for Individual Rights in Education, which is a close monitor of free speech in the university environment, has said, quote, "Many private universities grant students robust free speech rights." And in fact, when you look at policies of publics and privates, they do that. So Section 230 has not been a pass for widespread censorship, nor has it led colleges and universities to ignore complaints about the actions of someone using their networks or sites hosted on their servers, because to ignore complaints would be in direct conflict with the educational mission. Not only do colleges and universities want to ensure that their facilities are protected for teaching, research, and service, but a key aspect of their mission is helping stakeholders develop the skills to critically assess ideas and expression and engage in civil debate. This is a core function that we are engaged in, is trying to help students and others understand and think critically about and bring information literacy skills to the views and the ideas and the expression that they encounter online. And colleges and universities also have, as part of that mission, developing an appreciation for deliberative decision-making and due process. So the ability to, to take a complaint and then, as Sydney mentioned before, have that be the start of a conversation to take a look at, okay, what has someone said? Is that problematic? If it is, why? And to foster a conversation. So Section 230 doesn't cause colleges and universities, in my experience and in my study, to blow off complaints about online misconduct. What it does is let them address those complaints deliberatively without fear of litigation and as a matter of teaching and learning within an academic community. When instead colleges and universities have to litigate something, lawsuits basically stop community conversation. Okay, they divert money and people and focus from pursuing the mission. And even if a college or university wins a case on the merits down the road, it still has to pay the lawyers. It has to send a bunch of people to meetings and depositions and hearings, all of which is a drain on resources, and again, a diversion of those resources and that attention from having the much more important conversation, which I think gets at the heart of what people are so concerned about with online speech, is the ability and the skill to engage with information in a deliberative, critical, valuable, productive way. Okay. So why is Section 230 so important? What about it as it currently stands makes it important? First, I think it's broad. Okay, so it covers all claims that might arise with respect to someone's speech online, that user-generated content, except for those that are explicitly accepted. Just a handful of things that are accepted. They're important things, but what I mean by when I say it's broad is there's a wide array of state tort claims that people might bring to bear and other types of state and federal causes of action that that people who are concerned about online speech and their attorneys might use to pursue a complaint. And Section 230 is broad in saying none of those claims, okay, are viable. So as long as you are not the creator or developer of the content, and you're an interactive computer service provider, those claims go away. And that's a great deal of comfort. The other is that typically these claims can be dismissed early, and that is a procedural protection before a lot of time or money have been spent on litigation. And that is what allows, again, all of these activities to go forward without the fear of a great deal of cost and diversion of resources. That means that any reforms that look to carve out new exemptions from Section 230, and there are several, we should pay attention to the impact that would have. And the more broadly worded or vaguely worded they are, and there are some that I think are quite broad, the more they open that door again to litigation or the need for monitoring and all of the negative consequences that cascade. And of course, FOSTA, with which some of you may be familiar, is an example, I think, of where there were some unintended negative consequences to a very well-intentioned exemption from Section 230. So the last thing I guess I would say is another aspect of our mission is innovation, and others have talked about innovation. It's incredibly important. We care about preserving the space for our students, next generation entrepreneurs, to go out there and be innovators in this online space. And there are new sites cropping up, but it's exactly those startups that Section 230 was intended to protect, just like it explicitly calls out libraries and educational institutions to begin with, but it's very much focused on preserving that space for innovation. And I think colleges and universities would share the same concern that Greg mentioned earlier about, and others, about innovation going away if we only have big enough entities who can handle the costs and the risk associated with liability for user-generated content. So I will stop there, and I'm happy to help answer any questions.
Thank you, Beth. That is fantastic. I appreciate it. I would like to invite our panelists to all come back on camera for a moment, and I want to thank you all for your statements. We've only got about 10 or 12 minutes left. And so I'd like to have a little bit of a back and forth conversation before I ask you all to provide final statements. One of the things I was thinking about, Beth, as you were talking is, I know that we do not have a member of elementary education on here, but it reminded me of a conversation that I actually had with my son, who just finished doing his final year of junior high remotely because of the global pandemic. And we're talking to him a little bit about Section 230 and the work that I do on it. And he was saying, well, you know, my school is all online, and we have these chat functions, these tools that we use to communicate with our teachers and with the students and things like that. And they put rules and restrictions on that, and they tell us things that we can and cannot say. And does 230 protect them? I said, well, my understanding would be that yes, it definitely does. And so I started thinking about the ways in which certainly the global pandemic has heightened people's concerns around issues regarding content moderation, and it's why in a social media environment, they've kickstarted a lot of conversations around what's happening that have become focused on 230. And we want to make sure that they're not focused on 230 to the detriment of how it's used throughout the internet ecosystem. But I want to focus on how 230 protections have become, how we have realized that they've become more important throughout the same pandemic issues. Greg, you had mentioned the issues surrounding people using Wi-Fi in parking lots as a good example of that. But I'd like to see if other panelists have examples of how the pandemic has heightened our understanding of why 230 is important.
Well, I'll just jump in to say, absolutely. You know, I was teaching online for 15 months. I think many people, certainly in the K through 12 environment, absolutely. And so much of that programming, as Greg rightly noted, programming has moved online. And I suspect that much of that will remain online, actually. We really discovered a great deal of value to online programming. While we're all happy to come back face to face, I think this fall semester, there's still a lot that can be very valuably done online. And although there are plenty of use, terms that schools themselves impose on access to resources, of course, we all have use policies. What 230 does is make sure that we can enforce those use policies without fear of separate litigation. That's exactly how 230 arose, was, not wanting folks who attempt to moderate responsibly on their networks, exposing themselves then to complaints that, oh, but you missed this, or you didn't deal with this issue in the way that we think we should. So I think there's plenty of scope for 230 to still be quite relevant, and especially post-pandemic in this world of knowing that we'll still be doing quite a bit virtually, I think. So.
And I'll just add on here, just coming out of 2020, what a year in just so many respects. But just from a content moderation perspective, the hits just kept coming. We first started with all the COVID issues, transitioned right into the protests and marches that were occurring all last summer, and then right into the election and the fallout from the election. And it was just kind of this nonstop barrage of content related complaints or disputes or things like that. One of the things that sticks out in my mind was very, very early on in the pandemic, when we were going into lockdown. There were two issues I think that could have been controversial in other circumstances, but in the context of the pandemic were somewhat easier to make. Which one was that there was a lot of folks sort of profiteering off of some of the things, setting up websites, for example, to sell what they claim to be COVID treatments or COVID vaccines. And I think it was really easy for us. We don't normally kind of want to make value judgments on the validity of content. But I think in that case, in March of 2020, there was no treatment, there was no vaccine. It wasn't really a free speech issue; it was a scam, and it was in Section 230. I think gave us the courage to go ahead and just take those down, knowing that we weren't at risk of anything coming back to us. And then the other thing that was coming up was, I think there was a point in time where the Department of Commerce had declared that certain PPEs were critical medical supplies or something like that. And so finding folks who were gouging those types of things and holding out Q-tips for $5 a piece or something like that, it was kind of easy to take action against sites like that. These were, of course, minuscule in comparison to our entire customer base, but they caught a lot of attention, of course. And when they were detected, we knew that Section 230 gave us the ability to move against those types of sites. In other circumstances, we would probably be hesitant to say, well, what's a fair price for a Q-tip when you're not in a pandemic? What's a fair price for a supplement or medication or whatever. But I think under the umbrella of a pandemic, a lot of those decisions were made much simpler, and 230 gave us the toolkit we needed to go after them.
I want to just pick up one thing that both James and Beth have mentioned, and that's how the pandemic has changed our service models. I think that going forward, the library will, I think the online programming will always be a component of what we do. And one example of that is we have a library for the blind. It's the high school library for the blind, and they serve patrons with print disabilities and other kinds of disabilities that might prevent them from accessing the collection in the ways that sighted readers might read or might access them. And we often have tech classes where we help those patrons understand how to use assistive technology to let them access to the internet, to read the ebooks that we've produced or created or licensed. And those classes, it was a good day when we had 30 people in those classes when they were in person. And when the pandemic hit, we were hitting closer to 130, 140, 150. And that's because there were a number of patrons who were just simply unable to physically come to the building and that we didn't know about. We were starting to do some reach out, but when the pandemic hit, it really opened up a world to these folks who were unable to come in person, but were able to access our trainings online. And now those same folks are now able to access the internet in ways that they weren't able to before. They're able to read ebooks. They're able to listen to talking books. And I think that component is that online education component is going to continue. And that's why 230 is so important to us, to allow us to continue to offer those kinds of services.
Fantastic, Greg. I appreciate it. We do have one question in the chat. It's going to be our last question. I'm going to go ahead and read it. And I'm going to handpick James to see if you can field this one for us quickly before we head to final statements, because we're running out of time. The question is from Andrew McFarland. It says, we believe that the biggest social media platforms are acting as common carriers of public speech. We think there's a critical distinction between censoring based on content versus censoring based on viewpoint. These sites need to moderate content like violent or overtly sexual posts. However, they shouldn't deny your participation based on your viewpoint, including your political preferences or religion. Should social media companies be prohibited from censoring a person or the content that a person posts based on the person's viewpoint or the viewpoints expressed in the post?
Well, I guess thanks for the question, Andrew. I think I can't speak for the social media companies. None of them are here or members of I2C, but I think that they would probably agree with that statement, is that you should focus on the content and not necessarily individuals. I know that from our perspective at GoDaddy, we have a number of categories of content in our terms of service that we have decided we don't want on our platform. They may or may not be legal or illegal. That's up for debate, but that's just not our focus. It's not our mission. It's not the audience that we're trying to reach. And so we're drawing some boundaries around some of those topics as just really not in furtherance of our mission or the interests of our customers. And I think that other social media companies, and really all other companies, just need to make that determination for themselves.
Thank you, James. We are reaching the end end of our time. I'm going to ask you if you want to make one final, very quick statement as we close things out, and we'll go down the list from there.
No, I've chatted way too much already, Christian. Just to thank you and thank all the other panelists and attendees. This is a great session.
Thank you, James. Sydney, do you have a final statement you'd like to make?
I do. So way too often, the Section 230 debate has been focusing on social media companies and their content control policies. But the reality is Section 230 protections go well beyond those types of businesses to include every sector of society, and several of which are on this panel. So what we really need is for website owners to have strong acceptable use policies and for them to strictly enforce it. Getting rid of 230 is a misguided approach that will only place an expensive burden on unintended businesses, hosting providers, cloud providers, email solutions, and many more organizations that have to hire several more employees to figure out how to modify those agreements with their customers to allow for that additional monitoring. And in the end, we'll be left hoping that our customers don't terminate their agreements in search of offshore providers with higher data privacy standards.
Thank you, Sydney. Greg?
Just a quick word. As legislators think about 230 and 230 reform, I think you've got to keep in mind the unintended negative consequences that may come out of some of that reform. Think about how it's going to impact libraries and educational institutions like us, so that because we rely on 230 so much and we are not as well resourced as some of the companies that they may be targeting in that legislation. So consider us, consider those library values that we talked about, and think about how any changes to 230 might advance those values.
Thank you, Greg. And Beth?
First, just thanks again, Christian, and thanks everyone. I guess what I would say is that where I think I see a lot of emphasis in the 230 reform debate does center on size. And it's interesting that even this last question that we got was about the biggest social media companies. I think there are other things going on in the 230 reform discussion space that are worth thinking more about and looking into more. And one, there's obviously been a lot of discussion about antitrust issues and whether or not those should come into play when we talk about the power of really big companies. You mentioned common carrier regulation in there. And there's also been a fair amount of discussion and some scholarly recent discussion about what would better transparency look like in terms of policies of moderation. And so I think those are all areas that are valuable to have continuing discussion on. But I echo what everyone else has said about making sure you think about unintended consequences. And there I'll just end with what I said before about vague language and legislation. Every one of the reform proposals I've seen, except ones that just say just repeal it, but everything else struggles a bit with language. And I can see all the ways in which we would be going to court to litigate the meaning of this language, and that cost and risk profile itself would have a significant negative effect on the sort of entities that we're talking about here. So thank you.
Thank you, Beth, and thank you for thank you to all of our panelists today and our attendees. We really appreciate you coming to learn about 230 and its broader perspective. Again, I am Christian Dawson, Executive Director of the Internet Infrastructure Coalition. We go by I2 Coalition. You can find out more about 230 and contact us at i2coalition.com. You can contact me directly at dawson@i2coalition.com. I would love to be a resource, to continue to be a resource for legislators and regulators who are looking to figure out paths forward on how they are going to deal with solving problems online as things advance without causing negative impacts to organizations like the one you heard from today. Thanks to all of you, and we will bid you adieu and hope to continue this dialogue as things progress.